Hi everyone, I'm here with Dana Cohen. He's a local attorney in North Andover, and he helps me with most of my deals with my buyers and sellers in real estate. So when we first got here, you sat down with me and you sort of broke down everything that you do for me in the background when I have a buyer purchasing a house. If you could just lay all that out for me one more time. My buyer's buying a house and we come to you, we've got an accepted offer.
So usually we'll get contacted by Sean and then the buyer, and we'll find out who the lender is that they're working with. The very first step we do is the purchase and sales agreement, where we will put terms in there to protect the buyer and put in the proper contingencies and make sure they're protected.
Now, what happens if I don't submit an offer that says, contingent upon something? Let's say there's a clause that I haven't put into the offer. Can you get that into the purchase and sale, or is it very difficult for you to get into the purchase and sale if it wasn't part of the offer? Like, let's say we had a home inspection, or we wanted to do appraisal, or we wanted to protect something like that.
So it is a little more difficult to get the language into a purchase and sales agreement if it wasn't already in the offer. So it's great to work with educated realtors who know to put those contingencies in the offer, and that language will carry over into the purchase agreement. But we have had many agreements where we were allowed to put the language in to protect the buyer. It really depends on the seller's counsel and how they feel about adding those contingencies. So once that agreement is signed, then we'll order the title examination, municipal lien certificate, and plot plan. And those three items are necessary to make sure that the title's clear, that there are no encroachments,
Right.
and that the taxes have been paid on the property. And if anything is due, that we make sure they get paid at closing.
So I've ran into a couple of properties where it's been listed and then you've found out that it was in a flood zone. Is that a good out for the property? So they didn't advertise it was in a flood zone, we find out it's in a flood zone. Is that an easy out for you, or is that a hard out for you once we've already gone to purchase and sale?
So we usually put that in as a contingency in the purchase and sales agreement, subject to the property not being in a flood zone, because we don't want the buyer to have any surprises or have to pay a premium for the flood premiums. So we usually protect the buyer up front with that language in the purchase agreement.
Awesome. All right, so we've got the title, we've got the
plot plan.
See, this is why I hire an attorney, because he knows what he's doing. So we got the title, we got the plot plan, and now you're back to the lender.
Yeah, so then the lender will do their due diligence and give us a clear to close. And once we get that, then we schedule the closing, where the buyer would meet with us in our conference room and get all the documents signed. And once they're all signed and we get approval from the lender, we can upload and record electronically with the Registry of Deeds. Usually the sellers won't come to the closing. Their attorneys will get us documents in advance. So it's just a one-on-one with the buyers at our office, which is great because any questions the buyer might have, we can answer for them. And then once it's all recorded, we'll email securely all the documents to the buyer, and it's a happy day. It's a lot of fun, and we enjoy what we do.
Awesome. Dana, thank you very much for coming by.
Thanks for having me, Sean.
All right. Have a great day, everyone.